We're here with Attorney Harry F. Bosen Jr. in Salem, Virginia, to discuss driving under the influence or a charge of DUI in Virginia. Mr. Bosen, in Virginia, what constitutes driving under the influence?
Driving under the influence in Virginia can be if you have 0.08 alcohol content in your blood or breath at the time of the driving. A lot of people have the misconception that you have to be drunk to be under the influence. That's not the case. You can also be under the influence of a combination of either drugs and or alcohol. One of the things that's also a misconception is that if you're 0.08, that is the presumption. That is a presumption in Virginia, but it is also a standard that if you are 0.08 or more, you can be considered under the influence and in violation of the statute, irrespective of whether or not you're actually under the influence. What that means is you could do maybe great on your field sobriety tests, and the next thing you know, you're getting charged with DUI because you're 0.08 even though you were not under the influence, at least in the perception of doing well on the tests. So any combination of drugs and or alcohol in your system can put you under the influence, or 0.08 or more alcohol content.
And what are the punishments for DUI in Virginia?
Can receive up to 12 months in jail, $2,500 fine, and loss of license for 12 months for a first offense. For subsequent offenses, the punishments are greater, including if your blood alcohol content is much more than 0.15 or over 0.15 or over 0.20, you can receive enhanced specific punishments.
Are the punishments for driving under the influence of alcohol the same, or are they different than the punishments for driving under the influence of another drug?
They're all the same. If you're driving under the influence of anything, the punishments are the same. Keep in mind that some of the consequences can also be you'll have a restricted permit. If it's a second or subsequent offense, the punishments are more. You can receive active jail time. In particular, if you have a 0.15 or a 0.20 or more, you get active, actual, non-suspendable jail time. You can also be ordered to go to VASAP, which is an alcohol education program, in order to get a restricted permit.
Are there other charges that sometimes accompany a charge of DUI?
Yeah, a lot of people get the charge for which they were stopped, like speeding, reckless driving, running a red light. Some people don't consent to having their breath or blood taken. They can get a search warrant to take your blood, but if you don't consent to take the breath test after they read you the implied consent, then you could be charged with refusal, which carries a punishment of up to 12 months loss of license, unless it's a subsequent offense. If it's a subsequent offense refusal, you can get misdemeanor punishment.
And when you talk about refusal, are you talking about the test that the officers may offer you after the field tests?
Yeah, this is the breath test at the station. If the breath test isn't available, they can ask you for a sample of your blood. If you refuse, they can charge you with refusal, or they can go to get a search warrant and take your blood from you, physically take it from you. That's now permissible, provided they get a search warrant.
And what can an attorney do in a DUI case that a regular person might have difficulty doing on their own?
Well, an attorney can do a lot of things. They're going to know the ins and outs of the defenses, which I won't go into detail. But as an attorney, we can file subpoena ducis tecum and get the breath test machine records and see if there's any discrepancies in those records and that sort of thing. We also know whether the police officers have conducted the field sobriety test properly in your case. There are lots of different things that we can do. Perhaps there's a challenge to the probable cause for the stop, whether the officer had articulable suspicion for the stop, probable cause for the arrest, all of these various things.
And what should someone consider when looking for an attorney to help them with their DUI case?
You should consider the experience of the attorney in doing DUI cases. For example, I've been doing these cases for over 42 years. I know pretty much all the ins and outs. If you hire an attorney without that kind of an experience, they may not have the experience to know of all the avenues to explore. For example, if a person has GERD or gastroenterological reflux disease, which some people call acid reflux, many times a defense can be based upon that because that disease can skew the test results. A lot of attorneys would have no clue on how to do that.
And how do you typically approach defending DUI cases?
I approach them as I would approach trying a murder case. I look at every nook and cranny of the case. I look behind every tree. I look under every rock. I thoroughly examine the police officer's report that's in the Commonwealth's file. I subpoena the breath test machine records, and I look at all those records to see if there's any avenues of defense. I look at all the health issues on the case to see if there's any avenues of defense.
And are there other factors that affect the outcome of a DUI case?
Well, there could be other factors that affect the outcome of a DUI case, but that would depend on what's in the officer's report, such as whether or not he had, as I indicated previously, articulable suspicion for the stop in the first place. That's one of the best ways to beat a DUI case. Challenge the stop. Sometimes you can challenge the actual arrest based upon whether that arrest was based on actual probable cause.
We've noticed a large variance in attorney's fees in our area for DUI cases. Some are as little as $500 and some go into the thousands of dollars. Why is there that large difference in fees?
Well, a lot of attorneys will charge a very low amount of fees and do a very poor job. Some will do a great job, but a lot of attorneys do not have the experience and charge low fees because they're not going to do much on your case. Some attorneys that I've seen will actually go to see the Commonwealth's file the very morning of the trial, and sometimes in the courtroom right before the trial is set to begin. An experienced attorney would never do that, but you'll pay more for an experienced attorney. You'll pay for an experienced attorney to develop your case properly. And a cheap attorney will generally get you a cheap result. That's not always the case. When I first started out, I would charge a lesser amount of fees, maybe $750 or $1,000, but I would do the same amount of work that I do now because I took pride in my work. A lot of attorneys that charge a lot of money will do a lot more work on the case. And you've got to beware because some attorneys charge a lot of money and still go to court and look at the Commonwealth's file for the first time on the day of trial. If you see an attorney up there looking at a DUI file right before a trial is to begin the morning, you've got a problem.
And what types of outcomes do you typically get in DUI cases that you handle?
It depends. DUI cases are extremely hard to defend these days. They're extremely hard to beat. Sometimes you want to get a lesser included charge. Sometimes you want to lower it from a subsequent offense to just a first offense. But you've got to do your homework and your work before you get in there. Sometimes you can beat a DUI case on the merits. Sometimes you can beat it on a technical issue. It just depends. As far as what my results are, that depends on the case. I get good results on a lot of cases. I get a lot of cases that I settle for a lesser included offense because I have potential defense in the case that the prosecutions are worried about. And sometimes I have other types of issues in the case that the prosecutor just wants to give the defended a break because I've presented a real good case for a break in that case. Sometimes we just beat the case on the merit by trying the case.
And when you say get it reduced to a lesser included charge, what would be an example of a lesser included charge?
Well, like getting it to down to something like reckless driving. Sometimes people are charged with reckless driving and DUI at the same time, and maybe you get rid of the DUI and you take the reckless driving as a possible benefit in the case, a possible outcome of the case that's a lot less problematic on you. DUI has a lot of repercussions on people. It costs people jobs. You can't hold a commercial driver's license. Some people need their driver's license not to be restricted while they're driving at work. Maybe some people have classified clearances for the federal government or companies that are contracting with the federal government. They need these security clearances to keep their job. A lot of people, while they drive on the job, they may drive company vehicles, and they can't drive company vehicles anymore because DUI has cost them that opportunity because the company insurance wouldn't cover it.
If we may go back, you mentioned seeing some attorneys go into court on the day of trial and review the Commonwealth's file just before the trial starts, indicating a level of unpreparedness at the trial. How does that contrast with what you would do in one of your cases?
One of the first things I do is within the first 2 to 3 weeks after I get a case, after I've issued subpoenas and filed appropriate motions, I will go see the Commonwealth's file and read it and record it in handwriting, and then usually I'll transcribe that into a document that my client can read. But I'll do that within 3 weeks of being retained on a case.
In reviewing my notes, I see you've done some work with university professors in relation to the potential problems with the reliability of the breathalyzer machine that the Commonwealth uses. Would you care to talk about that at all?
Just briefly, the ECIR2, which is the breath test analysis machine that's used in the Commonwealth of Virginia, we think has a lot of deficiencies, and there are a lot of procedures in using that machine that we do not think is adequate and correct. And I can't go into the detail on that because I would use that on each individual case, and I do not want to alert the Commonwealth's attorney as to what's coming.
I see also that you have spent some time working with the Department of Forensic Science and reviewing their records. Would you care to talk about that at all?
Well, we've subpoenaed over the years a lot of records from the Department of Forensic Science, which essentially controls and runs, certifies these breath test machines. And we get their records and we pour through them with a fine-tooth comb, as I indicated earlier, to make sure that they've kept their records up to date and that they're using the proper procedures to certify and recertify these machines, and the testing of these machines. We check on that as part of our case. Thank you very much.
Mr. Bosen, thank you for speaking with us.